Welcome to Allred, Morocco, and Goldberg's first Facebook Live Know Your Rights question and answer session. I'm attorney Gloria Allred. And first and foremost, we hope that all of you are staying safe and well, and that in uncertain and unprecedented times that you are protecting yourself and your family. Here with me today are three of the partners from my law firm, and I would like to introduce each one. We have with us Dolores Leal, who's been my partner for many decades. We have Renee Mochkatel, who is also a longtime law partner of mine, and John West, who's been my partner for many, many decades as well. All of them have a great deal of experience in employment rights, and we thought that today would be a good time to start our Know Your Rights, meaning your legal rights, with a flood of questions that we have been receiving about COVID-19 and the workplace. So what my partners and I hope to accomplish with our time today with you is to answer what we perceive are some of the frequently asked questions on this topic. Specifically, Dolores will address workplace safety issues, including PPE questions. Renee will address pretextual layoffs, and John will address employees' privacy rights and right to accommodations. Please note that all of us on this panel are licensed to practice law in California, and the answers that my partners are going to provide are specific to California law. Please keep in mind the law may be different in other states, and we're providing general statements of the law and are not giving legal advice on this panel on any one particular case. So let's start right now and address the first question to Dolores Leal, and it's about PPE. Dolores, we've heard from so many essential frontline workers concerns over lack of personal protective equipment such as masks or gloves in the workplace. And many have asked whether employers have to provide their employees with PPE. Dolores, what's the answer to that question?
Well, Gloria, it depends on a few things. Number one, what the CDC guidelines say. Whether the individual is an independent contractor or an employee, and what industry the person works in, what position the employee holds. So at this point, the CDC guidelines are constantly changing. So I would recommend that if any viewer has a specific question, that they contact an attorney or even check out the CDCR website. The CDCR, by the way, is a Center for Disease Control.
Thank you, Dolores. Let's turn our attention now to retaliation for complaining about workplace safety issues, which many people feel is happening to them, especially frontline workers who are our heroes. So what if an employer has refused to provide employees with PPE and one of the employees complained to management about the lack of personal protective equipment? Can that employee who complained be fired?
Well, most employees in California are what the law calls at-will employees, which means that the employer can in fact terminate an employee without any reason whatsoever. That's the law. However, if the employee can prove that the real reason they were terminated is because, and I'm emphasizing that word, because they complained about health or safety issues, then the employee may have a claim of retaliation, retaliatory wrongful termination claim.
Well, let's broaden the subject of that last question a bit. What if employees believe that their employer is not following health or safety guidelines designed to protect employees at work? What should those employees do?
I would suggest that the employee first try to resolve the issue through the company's human resources department. Most companies have human resources departments. If they don't, they should then speak with their managers or the general manager or the individual who is highest in the company. I would also recommend that the employee put their complaints, their issues in writing. That's very, very important. And they should do that perhaps by email. That way they have a record that they raised this issue with the employer. If the employer does not respond, does not act on their complaint, then the employee should contact the California OSHA office. OSHA is the Occupational Health and Safety Administration to file a complaint, or they can also contact the federal OSHA and file a complaint.
Dolores, let's go a step farther. After the employee complains about the lack of PPE or other safety issues, the employer is harassing the employee, perhaps by micromanaging the employee, finding supposed errors in their work, or just being rude toward them. Does that employee have a case?
Well, it is illegal for an employer to harass an employee who complains about the lack of PPE or any other health or safety issue. If the harassment that you've described is what the supervisor is doing, I would again suggest that the employee go to the company's human resources department, file a complaint, or send an email documenting the complaint. And hopefully the HR department will put a stop to it or speak to the supervisor in order to stop that type of harassment. Again, I would reiterate that the complaint should be put in writing.
Dolores, what are the employees' options if they feel that they're being retaliated against at work? Specifically, what should they do?
Well, if they're being retaliated against, again, they should complain in writing to human resources. And it's very, very important, I say, to put it in writing simply because there are many cases that we've handled in the past where the employer says, we fired them, yes, but they didn't complain. There's no proof because the employee didn't put it in writing. So it's very important for the employee to document the harassment. If the employee believes that they suffered what we call an adverse employment action, in other words, they were written up or they're being unduly scrutinized at work, again, I would suggest that they complain to human resources in writing.
And finally, Dolores, you mentioned termination. What does a wrongful termination mean? How can employees prove that they were wrongfully terminated?
Well, the employee, again, in California, all employees are at-will employees. So a wrongful termination means an illegal termination. It doesn't mean an unfair termination. So to answer your question, the employee would have to prove that the real reason, the true reason behind the employer's decision to fire the employee was an illegal reason, i.e., the employee complained about health or safety issues. The employee complained about other things that they believe to be illegal, such as, for example, I complain that I'm being discriminated against, or I believe I'm being harassed because of my race, religion, color, sex, age, national origin, medical condition, disability, sexual orientation, my marital status. In other words, all reasons that the law say are illegal. So if I complain about one of those things and the employer is upset that I complained or opposed one of those things and I'm fired, that is what we call a wrongful termination claim, a retaliatory wrongful termination claim.
Dolores, one last question on something you just said. There are some employees in California who have contracts. Are they at-will employees as well?
Depends on the contract, Gloria. If the contract is for a specific term, then that means that they will be, or they should be, employed for that term. So it's not at will.
All right, thank you.
Sure.
Let's turn now to another question that really affects so many employees today because of COVID-19. And that is what we call RIFs, reduction in force, RIFs. And some employees who feel that the employer is giving pretextual reasons, and we'll talk about what that is, for furloughing or laying off or terminating employees. So Renee, this question is for you. Speaking of individuals who have lost their jobs, we've seen the reports. Employers have laid off or they've furloughed millions of Americans in the past several weeks. Can someone still assert a claim for wrongful termination if their employer has laid off hundreds of people because of COVID-19?
Thank you for the question, Gloria. And echoing what Gloria said earlier, I hope everyone who's listening is well and taking precautions to stay well. And the answer to that question about whether or not somebody can state a claim, the answer is probably yes. But initially, we have to look at the various factors that go into whether or not somebody has been let go for a legal reason or for an unlawful reason. For example, in echoing some of the things that Dolores said, if you've complained 2 weeks ago in writing about sexual harassment by your boss, or if you complained in writing, I think I'm being treated differently in the workplace because I'm over 40, and then suddenly the furlough or the layoffs happen, and you are lumped in to the layoff pile, the question becomes, were you laid off because of COVID-19, or were you laid off because you made a written complaint of discrimination or unlawful conduct in the workplace, and therefore the employer is now using this as an excuse to get rid of you? It takes a lot of analysis, and the best thing I can recommend is that you would call a lawyer and review the facts of your termination or your layoff so that we can determine whether or not this was a legal or an illegal layoff. Remember, an employer can't use COVID-19 as an excuse to violate your rights.
In other words, can't use it as what we call in the law a pretext.
Correct.
For violating your legal rights. Thank you.
That's right.
Sometimes, Renee, employers will give employees a separation or severance agreement at the end of their employment. What should an employee do if their employer gives them a severance agreement as part of the layoff and says, sign this if you want to get your severance of a week or two pay?
Well, that's probably a relatively common occurrence. What an employee should do if he or she is given a severance or separation agreement is, in all honesty, talk to an attorney, because an attorney needs to talk to you about whether or not this layoff is a legal layoff or an illegal layoff, whether it is, as Gloria said, pretext for something else, or if in fact it's really based on the COVID pandemic. What the reason for this, and the most important part that I want to impart to you, is that these releases or these severance agreements include a paragraph usually that's called a release of claims. What that means is if you sign this agreement in order to get whatever small severance you may be offered, you are waiving all of your rights to sue your employer. And that means even if they did something illegal. So if you have any doubt in your mind about what the real reason is for your layoff, call a lawyer, review the facts and circumstances of your layoff with a lawyer so that you can at least get a legal opinion as to whether or not it makes sense for you to sign this agreement. Now, one of the things that these agreements provide for is if you are 40 years or over, you will have the right to sign the agreement, but then 7 days later, up to 7 days later, you have the right to revoke the agreement. The agreement should state that in writing and give you that information. So if you sign it on day 1 and you talk to a lawyer on day 3 who says, you know what, I think you might have a claim for a retaliatory layoff, that you complained in writing of sexual harassment or discrimination, you can revoke that particular agreement. You may have to give back the money. You can't keep the money and sue them. You'll have to give it back. But this will allow you to pursue your legal claims. Remember, COVID does not eliminate an employer's duties and responsibilities to you under the law.
Well, those are very important points you made, Renee, and I might add, because we just had someone contact us this week that she had signed a release. She was 25 years old, and she got her 2 weeks pay, but she didn't really know that by signing the release, she was giving up a claim that she had that could have been worth $1 million, and was very disappointed when I had to tell her that. So be very careful, everyone, about signing those releases. Better to talk with an attorney before you file what the employer puts under your nose as a severance claim, and you know, take a little time, and then you may want to sign it, or you may wish not to sign it. But let's go on, because there is another important issue as well about privacy rights and how those privacy rights intersect with what we call disability law. And I'm going to switch now to John West and ask about some of the common issues that arise once employees are back in the workplace. John, many people who have medical conditions that they want to keep private have asked, well, what kinds of medical questions can their employer ask them during the pandemic? What is your answer, John?
Sure. You know, life is complicated, and people have all kinds of medical histories that in general are none of the employer's legitimate business. And you don't surrender your rights of privacy when you go to work. You might have emotional issues, family issues, all kinds of things, or medical issues that you just want to keep to yourself. On the other hand, right now, the law recognizes that employers have a legitimate interest in keeping everybody at work safe. And they don't want to create situations where one person's medical situation puts others at risk. So right now, the law recognizes that an employer can ask questions, but they have to be limited to recognized COVID symptoms. Now, there's a list that's out there. It may be changing, so you need to be aware of that. But in general, an employer has the right to ask about symptoms only. Past that, an employee is entitled to say, the rest of that is my confidential medical information.
I think that's very important. Actually, we had a very famous case that our law firm won so many years ago, precedent-setting case where a woman who was applying to be a police officer was asked if she used contraceptives or if she'd ever had an affair. And anyway, we won a very important ruling on the privacy rights of an employee. So just when, you know, have a red flag go up in your mind, everyone, when you hear medical questions being asked of you in the workplace. Some are okay, some are not. You still retain a right to privacy about some issues. So John, suppose someone has COVID-19 symptoms and was supposed to start a new job right away. When they told the company about their symptoms, the company withdrew their offer. Do they have a claim?
That's a great question, and it's a perfect question for the time, because we are hearing situations like this all the time. And the answer relates back to the medical privacy, the medical issue that you just asked about. The employer has the right to maintain the safety of the workplace. In fact, it not only has the right, it has a duty to provide a safe workplace. So if the employer has a legitimate need for the employee to start right away, and that's not just a pretext to cover something else up. The employee has the symptoms. It looks like the employer would be justified in saying, I'm sorry, we can't have you right now. We have to withdraw our offer. That might be different in different times and different circumstances, but right now that appears to be the case.
John, some people have also asked whether their employers can require them to stay home during the pandemic, even if they needed to work and they want to come to work. What's the answer to that question?
this is probably the clearest answer that of the answers I've given. It looks like if the employee has signs of COVID, the employer does have the right to insist that the employee stay home, regardless of the employee's sincere desire to get back into work.
So let's now go to the opposite end of that question, which is there are some in the opposite situation whose employers want them to come to work, even with a medical condition that makes them vulnerable to COVID-19, because the job can only be performed on site. Do those employees have to report to the work site?
The answer to this is kind of a mix of legal questions and medical questions. At the end of the day, people are not entitled to act merely on their feelings. But if they have a vulnerability and actually they have a disability, that disability would entitle them to say that, you've got to make accommodations for me, see if I can work off-site. But by the way, a disability is a major life, is an impairment that makes performance of a major life activity difficult. Major life activities refer to all kinds of things that you have to do at risk. So if someone is at greater risk due to a disability, the employer is required to reasonably accommodate if that can be done.
Mm-hmm.
And that means that the employee may get some special treatment, the ability to work from home.
And of course, we know that our friends and coworkers who do have what are legally called disabilities have many abilities, and sometimes have more abilities in certain areas than those who do not have disabilities. And so they make important contributions to our workplaces. John, finally, others have asked about circumstances when the pandemic has made their pre-existing emotional disorder, for example, depression or anxiety, much worse. Are their employers required to grant them additional accommodations?
This is another one of the great questions for our times. Everybody is working under unprecedented conditions. Kids at home, one spouse laid off, and their ability to cope is pushed to the maximum. The question becomes whether these feelings that the employee is experiencing amount to a disability, that impairment of a major life activity. Unfortunately, the way the law is structured right now, merely feeling very, very stressed probably doesn't amount to a disability. But if the employee has genuine concerns about their ability to keep going under these circumstances, the employee might consult with a doctor and see if it amounts to a disability, and then have the doctor certify that, and that might open options either to accommodations or to a leave.
Thank you, John. And I want to thank everyone on our panel today. Dolores Leal, thank you so much. Renee, Mochkatel, thank you. And John West, thank you. All of them are, as I said, my law partners in Allred, Morocco, and Goldberg. So that's all the time that we have for our panel discussion today. And to those of you who are viewing, thank you so much for watching. This is the first time that we are trying this format to connect with you. And we welcome your comments on this first session of what I'm going to call Know Your Rights. Feel free to share your comments and your thoughts on the comments section of this post. Meanwhile, if you have any specific questions about your own potential claim, our law firm is open, and we will continue to provide free, confidential consultations about your job rights. Whether your questions are about the COVID-19 crisis or arising out of other issues at your former or current workplace. Please tune in next Thursday at 12 noon Pacific, 3 p.m. Eastern on my Facebook page for another question and answer session about Know Your Rights. Have a wonderful week. We're going to have a new topic, non-COVID-19 related, but important to your lives next week. See you then.